Welcome to Kaumudy Global. A Delhi court on Friday granted bail to Sharjeel Imam in a sedition case lodged against him for allegedly making an inflammatory speech at Jamia during an anti-CAA-NRC protest in 2019. He was in custody for the last 31 months. This case was registered at the police station in New Friends Colony, Delhi in 2019. It is important to note that as the proceedings of the offence of seditions are in suspension, he has been granted bail in IPC section 153, promoting enmity between the two groups of people. In this section, the maximum punishment is 3 years. Additional Sessions Judge Anju Agarwal granted statutory bail to Sharjeel Imam in view of his undergone period in custody in section 153A. He has undergone more than half of the period of the sentence. The court granted relief to the JNU student on furnishing a personal bond of Rs 30,000 and a surety in the like amount, including other conditions. The accused moved an application through advocates Talib Mustafa and Ahmed Ibrahim seeking statutory bail under sections 436. A CRPC was moved on behalf of the accused as he has undergone more than half of the sentence in custody. Sections 436A CRPC states that where a person has, during the period of investigation, inquiry or trial under the CRPC of an offence under any law, not being an offence for which the punishment of death has been specified as one of the punishments under that law, undergone detention for a period extending up to 1/2 of the maximum period of imprisonment specified for that offence under that law shall be released by the court on his personal bond with or without surety. His earlier bail application was dismissed by the trial court on October 22, 2021 in view of sections related to sedition and promoting enmity between groups. He moved the High Court against the order. Meanwhile, the Supreme Court passed an order on May 17, 2022, directing the government to keep in suspension all the cases related to the offence of sedition. Thereafter, he had again moved to trial court seeking bail in light of the direction of the Supreme Court. The trial court had directed the petitioner to seek clarification from the High Court on the provisions of sections 436A CRPC applied in this case. The Delhi High Court on September 26 clarified the issue in an application moved on behalf of Sharjeel Imam. The petitioner had withdrawn his regular bail application. Earlier, the trial court had dismissed his bail, saying a cursory and plain reading of the speech of December 13, 2019 reveals that the same is clearly on communal divisive lines. In my view, the tone and tenor of the provocational speech tend to have a weakening effect upon public tranquility, peace, and harmony of the society. However, the court had also said, in view of the settled position of the law, the issue of whether the said speech would fail within the ambit of Section 124A IPC or not requires a deeper analysis at an appropriate stage. Imam was arrested on January 28, 2020 from Bihar for giving allegedly a seditious speech and abetting riots in the Jamia Millia Islamia area in December 2019. According to the Delhi police, in the said speech, Sharjeel Imam was seen instigating a particular religious community against the government by creating unfounded fears in their minds regarding CAB and NRC. As per the prosecution, speeches delivered by the accused were seditious, communal and divisive in nature and were aimed at promoting enmity between different religions. After the conclusion of the investigation, the accused was charge-sheeted for the offence under section 124A-153A for the speech dated 13/12/2019. The accused was also charge-sheeted for offences under sections for Prevention of Damage to Public Property Act and under sections 25-27 Arms Act with aid of sections 109 IPC for instigating co-accused in committing the said offences. After taking note of the submission of both sides, court also observed that the fundamental right of freedom of speech and expression as enshrined under Article 19 has been placed upon a very high pedestal in the Constitution of this country, and its essence is well captured in statement of John Milton, the famous British poet and intellect, who says, "Give me the liberty to know, to argue freely, and to utter according to conscience above all liberties," the court had observed. However, the very same Constitution places a reasonable restriction upon exercise of said right inter alia on the grounds of public order and incitement to offence. That apart, Article 51AE of the Constitution also casts a fundamental duty upon citizens of this country to promote harmony and spread common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities. Therefore, it is no gainsaying that the fundamental right of freedom of speech and expression cannot be exercised at the cost of communal peace and harmony of the society, the court had said. Sharjeel Imam is presently facing various cases in 5 states, including Assam, Uttar Pradesh, Manipur, Arunachal Pradesh, and Delhi. This is Anjana signing off. Do like and share this video. For further updates, subscribe to Kaumudy Global.